10768 of 2024.
Yes.
This letter of charge sheet has been already filed.
307.
Investigation is already closed. And the 10 of the 9 has already granted bail loss.
They have been granted regular bail, not anticipatory bail.
Lordship, but some the 2 to 3% is also granted anticipatory bail. Lordship, kindly see the page number of the page number 58. 5 of the granted regular bail and the 4 is the granted anticipatory bail. The 9 of the accused is already granted bail.
Thank you. Dismissed. Go and apply for regular bail.
Lordship, because without any reasoning in High Court, are they dismissing the bail, Lordship, because only the previous.
So 307, Mr.
All are disputes regarding the property related, Lordship. That's why.
That shows it is double-edged actually.
Practicing advocate, Lordship. That's why.
Go and apply for regular bail.
Liberty to the.
It's always there.
Please, Your Honor.
Lordship, in this matter, I am behind the bar since last 5 years. So, Lordship, in this matter, that the NCB arrested these 8 people are there, and this
notice general 4 weeks.
grateful.
That seems fair. Dictionary, they co-accused Milord in that liquor case along with Sisodia. But she is the place to grant bail to Sisodia. In the ED case and 4 months Milord in CBI. Charge sheet and prosecution complaint Milord has been filed in both cases. Investigation is complete qua me in both cases.
5 months in ED case.
5 months in ED, 4 months Milord in CBI. Charge sheet filed Milord in CBI. Prosecution complaint filed Milord in ED. CBI is on record in the affidavit to state Milord that investigation is complete. The total number of witnesses, Milord, is 493 cumulatively in both cases. Milord, the number of accused totally is 57 and total number of documents, Milord, in both cases cumulatively is about 50,000 pages. Milord, she is a sitting MLC, she is an ex-MP. There is no chance that she will flee from justice or go anywhere. Milord, your Lordship would recall the High Court says, Milord, that she is not a vulnerable woman and therefore she will not get the benefit of, Milord, the proviso to 45. Milord, I respectfully submit that reasoning is also wrong because the proviso to 436 also uses the same phrase, that is for persons below 16 or women may get bail. The normal rule or the normal practice is that women do get bail unless, of course, it's a gross case or an extraordinary case. To create a distinction of vulnerable.
You are not a vulnerable woman like the.
What does it mean? Because she is an MLA or MLC.
You are MLA, MLC, you know what is right, what is wrong.
No, but
you are not an illiterate person.
Most important, I think, the High Court has missed the wood from the trees. There is no recovery. The allegation is 100 crores moved from the South Lobby to Delhi for this policy. 100 crores moved from the South Lobby to Delhi. And it was then it went to Goa for elections after that. But there is no recovery of any sort. Now the allegation against me, your Lordship might note and I'll deal with it, is that, she threatened a witness. Now, my lord, it is my word against them. There is no case. There is no
Their
investigation.
case is that you, on the very day,
Yeah.
you are arrested, they retracted their confusional statement.
With great respect, my lord. Her father was, my lord, her father is the chief minister. If somebody had to give a threat, the father and brother would do it. Why would she, my lord, do it? If she has people, my lord, they would do it. So unless you have, my lord, some investigation for a threat, it can't work. And something, my lord, now very important, I must tell you, lord. They say that she, my lord, when she was asked to give her telephones, she gave the telephones, but, my lord, they were differently formatted. Now, my lord, to show how, my lord, bogus this allegation is, your lordship may note only one thing, my lord. My lord, in a remand application of a co-accused on 26th November 22, my lord, they publicized that I have destroyed my phones. On 26th November 22, I was summoned for the first time on 7th of March 23. Your lordship notes that date, my lord. It is said, my lord, in a remand application of a co-accused dated 26/11/22 that I have destroyed, my lord, my phones. I am summoned, my lord, for the first time by the ED on 7th of March after 4 months. How can anybody say, my lord, 4 months earlier that I would have destroyed my phones? I have, my lord, given the phones because I said, my lord, some of these old phones I have given to my staff because I upgrade my phones.
Every day.
Not every day, my lord. People upgrade phones every 2 weeks. Every 3 weeks. My lord, it's like a toy. People who can afford it will do it. People change cars also every month or 2 months. So, I mean,
Like Mr. Rodgi.
no, I don't, but people do. It's like this, blood. People use it as toys or whatever. You change. So I changed the phones, and I got the phones. So what is the reason, my lord? Why?
Have you annexed that Manoj Sisodia order in this paper?
Sisodia.
We're carrying the paper.
Yes. Yeah, give it. And, my lord, with great respect, two major principles of Sisodia, apart from the fact that she is the co-accused. Bail is the rule and jail is an exception, number one. So you go back to Article 21. And number two, my lord, delay in trial. These are two significant milestones in Sisodia. Bail is the rule which goes to 21 and delay in trial. They are identically situated, my lord, and I would say, my lord, better than Sisodia. She is a woman, and therefore
Yes,
the rigors.
whether the statute distinguishes an ordinary vulnerable woman from a woman who is of a high status and
High status can never be the issue.
no, the reasoning given by the learned judge of the High Court in separate chapter is that she is not a vulnerable woman and therefore the law laid down by the Supreme Court does not.
I have.
Yeah, I show you.
It is not mandatory, my lords, kindly.
So it is not mandatory, but that is one of the factors.
Look at the provision, how it has been interpreted. I'll take my lord to this. As far as may I deal with the phone aspect first, my lord, then I'll come to this. She was summoned. She had one phone. She said, I have balance 15 or 16 phones. I'll produce later. When she produces between the date when she was examined and the date of production, she has destroyed many of them. I'll point out from the evidence.
How do you know she has destroyed? If I take it from a maid,
destroyed, she formatted it.
my lord, if I give it to a maid or a servant, and the servant deals with the phone, and I take it from the servant and
Format
give
an
it
iPhone. Why would you give it to a maid or a servant?
why not?
iPhone given.
So Rodgi, we have called upon him.
Sorry.
Kindly have a look at first section 45.
No, we are aware that it is not mandatory. Merely because a woman
Yes. And
should be ipso facto entitled, that's not a factor. But the question is whether the distinction
the
between.
facts of this case, discretion should be exercised in her favor. That would be the issue, my lord.
Yes.
Now may I only point out certain factors which would not require the exercise of discretion in her favor. That one of the important conditions is her conduct, which amounts to tampering and threatening witnesses. Well, kindly have a look at her. Giving a file. Into her involvement, but kindly have a look at her tampering is concerned. Yes, first is tampering. Kindly have a look at 139. That's 139.
Conduct.
Kindly. ED convenience compile, also having ED convenience compilation. Page 139, my lord. Question 50 starts with question 50.
You want counter affidavit or convenience compilation?
Convenience compilation. Question 50. Please produce your phone for examination. My lord, sir, got it?
One. The number 50.
139, question 15. Answer. As you have asked me to produce phone number so and so, 8008 and 66s, I called my husband. This shows there is a VIP number. Anyway, I am not commenting on that. Called my husband.
It is somewhat similar like Mr. Rodge or Mr. Raju's number.
Yes. But I am not on that. Irrelevant. I called my husband Anil from your office landline to send the phone to ED office, which was brought to the office by lawyers. Then I went down and collected the same and producing you for examination. Do you use FaceTime app? Yes, I do. What are the other apps do you use? FaceTime and WhatsApp. How long have you using this phone? I'm using for the last 4 to 5 months. You use Signal app? No, I do not. On examination of your phone, it is seen that there is no data records, calls or communications in FaceTime app in your phone. If you have been using this device for the last 4 or 5 months and you say that you use a FaceTime application for communication, then please explain why there is no data record of your communication in your phone which has been presented to me for examination by you. I have been busy in the last 10-15 days. I have hardly had my device with me. So probably the calls were taken on my landline. That's why probably there is no communication in this phone. You have mentioned that you have been using phone devices for about 4 to 5 months for the next and not just 10 to 15 days. Then please explain why there is no record of any calls that were received and missed in the FaceTime application. As mentioned above, I hardly use my device. That probably why there is no data. This is it. Above answer does not answer, but I have asked you to explain the reasons for this dispatch. I would like to reiterate my earlier statement. Now kindly have a look at then, my lords, kindly have a look at page 143.
Mr. Raju, phone is such a private thing, there will be other things in it.
Then,
Will any of us in this room hand over to anybody else the phone? For example, jocular messages will be exchanged. I am not on this case. I am just on the human conduct, normal conduct. You see.
There may be, therefore, there may be partial removal of those things. You can say that, you can come and say
People
that.
delete messages. I have a habit of deleting in group messages so many things. The school and college group, they put so many things in it.
But
I'm just
messages, there are all
as a
messages are
normal-
not, I am not saying it's
I mean, normal conduct, you see. Let us be common course of human conduct.
Normal conduct is you may have.
Any of us in this room.
Fair enough, but you may delay it, but you can't format the phone, that is one. But kindly therefore have a look at 143. I will answer this question after I read a few questions, madam. You are requested to produce all digital devices you have used in the past 2 years for examination on 16/3/23 along with details as sought in.
How is it possible?
She produces it.
No,
She
no.
produces it. I will furnish
No,
them
no,
all
normally if you
documents
purchase
and
an old
documents.
phone, either you give it to someone or when you purchase it, you get some discount on that.
It is not a case of replacement. It's a person using nowadays the fashion people use 8 to 10 mobiles.
Yes.
10 mobiles at simultaneously.
Some of the lawyers have at least 3.
I have two, Manoj. I have two, one big one. I tell my lords why I have two.
Private number because you'll be getting calls, otherwise constantly getting calls.
But there is another reason, my lords. I am Samsung savvy or Android savvy. I don't like iPhone. But for FaceTime, where my children and others, I have to have FaceTime. Therefore, I have two phones. But there are so many messages you can't delete. Every time in a Gmail account, as if box is full, pay so many rupees, will increase the capacity. Every 6 months, I have to do it because I don't have time to delete. You have to delete, look at the mails. Now, kindly have a look. She's asked to produce. Now, look at what has happened, Manoj. Yes. Now, 208, she produces. Kindly have a look at question 3, 4 and 5. So she produces, my lord, the other devices. Question 4. Have you formatted this phone with respect? I do not think so. Have you deleted data from this? I am not sure. I examined your phone reference. There are no contacts saved. There are 3 missed calls in the record history. You delete but you don't delete contacts, record history. No records of any calls other communication have. There are no pictures, videos, or even trash. Please state again whether you use this phone. It says when and why there is no data. I have used the phone. I do not remember the dates from when to when I used this phone. Acknowledge the status of the phone as you put it. It has been given to you for further. I do not remember when I used this phone last. Phone number was made public. I believe my office might have taken the SIM card from one phone and probably put in another phone.
That's the question, sir. I am not able to formulate it.
No, you are arguing from the reverse side. What is the material to show that she is involved in the crime?
Yeah, it's important.
I am sure. Then, my lord, I will argue
As a brother put it, this is negative proof. What is the, you must have some
No, I am
positive.
saying by discussion. I began with saying that my lords are not going to only the aspect of woman, but why this she is not entitled. I'll come to the fact.
Yes, therefore, what the learned judge is right. She is highly educated, sophisticated, and whatnot.
No, I have not completed this part. This is only showing that she
It is heartening to note that the applicant so-and-so is a highly qualified and well-accomplished person, having made a significant contribution to politics and social work, as enlisted by her in the pleadings.
That is the pleading. Therefore, the pleading. The judge is
No, no.
recapitulating.
The same were not disputed by the investigation agency. Her educational qualifications and the activities they are enlisted for the betterment of the society in the state of Telangana.
That's their case.
No, this is finding of the High Court.
But their case.
Are essentially one side of herself and is impressive. However, then.
So it is when you argue, my lords have said in umpteen number of judgment the status of the accused is
Not relevant.
Not relevant for.
So this is the other way of going.
But it was their case. That was dealt with by the learned judge. It was not that we have said anything. That was their case. Look at my status. Therefore, cannot be bail. That was their arguments.
No, they must have stated so as to satisfy the triple conditions.
Correct.
Prima
But
facie
that
case.
is hardly relevant. My lords are aware that status of an accused is hardly relevant for twin conditions.
That they must have argued to show that they have deep roots in the society. That must be a ground.
That can't be a ground under 45. That can't be a ground even for under 439. That can't be a ground.
Why?
Status of a person can't be a ground for bail. One has to look at the role.
37 years ago. Old heightened rule.
248. Kindly note, my lords, her first statement was recorded on 11th of March. Kindly have a look at the context, in this context, page 248. Her first statement was recorded on 11th of March 23, where she said, I'll produce other devices. She produces them. Look at what the forensic laboratory says at page 248. Kindly look at,
You have gone back to the convenience compilation?
yes, convenience comparison. I'm sorry.
Huh.
Kindly have a look at what the forensic laboratory says. 11th, kindly note the date 11th March. And when were phone numbers 3 at serial number 3, 4, 5 and 7 formatted? After she said that I'll produce the devices. I can understand a case where person is regularly formatting, regularly changing. This was not a case. This was a deliberate case where there's tampering with evidence.
Yes.
And then she said, not formatted. Therefore, she misled. She could have said, I formatted because there was sensitive data. I didn't want to give you sensitive data. Or she could have said, there was sensitive data. Please don't look at this sensitive data. Or she could have said, I've deleted the sensitive data. But she did format the entire phone. Therefore, look at her conduct. Therefore, her conduct shows that even if she is a woman, because she is destroying evidence, tampering with evidence, the phone may contain crucial evidence. Therefore, she is not entered. This is one
Do you
out.
have anything independent to show that this was the evidence which was there, which is tampered? This only shows a cell phone is formatted. Somebody has formatted a phone. Unless you show, look at the other end, the sender's end. This was there. Now this is formatted. This is deliberately concealed.
I'll point out.
Otherwise, it will only show that a phone is formatted. For tampering evidence, you need to.
We are CDRs. We are CDRs which would show that she was talking with the other accused. She was chatting with the other accused. We have CDRs to show her connection with the other accused. That. There is one accused in the CBI, not in the ED. There are chats with that person in that phone, but in her phone it's deleted.
What is the name of that?
Gautam Mutta. It is not that we picked up an innocent.
There is no such thing in the record, Lord, but my friend is saying. In the High Court.
140, please.
Nothing. Everything is on the data.
141. Now kindly have a look at question 63. Page 141 of my convenience compilation. First, she talks about Buchi Babu. I'll come to Buchi Babu. Yes, but I'll read the question. You have been shown WhatsApp chats between you and Sri Buchi Babu dated 27/10/20, which is extracted not from her phone but somebody else's phone, wherein he has briefed you about his conversation or discussions about investment in Gautam Mutta. Firstly, as per you, Sri Buchi Babu does not negotiate or discuss business on your behalf. Second, you have stated that you are not aware about Abhishek Boinpalli's investment with Gautam Mutta. Third, you have stated that you have no stakes in India Ahead News Channel. Fourth, you have stated that you never discuss any investment opportunities with Gautam Mutta directly or indirectly. All these four statements of yours are being contradicted, appear to be false when confronted with the digital evidence found in the phone of Sri Buchi Babu and your own chat. Please explain why you have given false statement. This is only one. So I'm just giving a sample. Therefore, it's not that only her phone is formatted. There is other evidence from other phones which corroborates that she has done it deliberately to conceal all this. Now, second is,
But if you see the date of this message, 27th October 20,
yes, ma'am.
when is the policy, the DICA policy?
Well, revenue policy had started by that.
21, 22.
No, that's when the policy came into force.
And
But
he-
the
but he's my CA.
background was already there in 2020 negotiations with bribe givers, everything was there.
He
in
is a CA, not a part of.
September 2020. That's our case.
Yes.
Now kindly come to Buchi Babu Bulos. Page 24 of our counter. 824. 824 of the bail application. Now, para 22 onwards, I'll read through that with my first
Oh,
one.
PDF page? PDF.
Page 823.
823 volume.
PDF 378, volume 2.
Oh, you don't have consolidated.
875.
823. Volume 3.
Volume 2.
That I have.
It's 824 of volume 2.
824, is it?
Yes.
Para?
Para 22 onwards, no? 22 deals with the fourth. Learned counsel for ED. Lots of order?
Yes. 823 actually.
823, yes. Learned counsel for the ED further contended that the conduct of the accused applicant does not entitle her to accept
Page,
of this court in her favor.
paragraph.
Paragraph number 22 at page 823. This is part of the order rejecting interim bail. This has not been challenged. Learned counsel for ED further contended that the content of the accused applicant does not entitle her to exercise the discretion of this court in her favor. In furtherance of this argument, counsel for ED drew attention of this court to forensic report. So submitted as per this report, some of the digital devices produced by the applicant before the investigation had been formatted after issuance of summons to her by ED. With specific instruction to this I have read. 1023. It is further submitted that applicant is thus guilty of activity destroying digital evidence to consider board of involvement in the case. 1024. Learned senior counsel to ED also submitted the Arun Pillai, who is the proxy of the accused applicant, retracted from statements earlier made by him during investigation after 118 days, and the only two statements which he retracted were pertain to accused applicant. It is further submitted that Arun Pillai made no complaint of being forced to make the said two statements at time when it was produced by the legal content. Retracted came immediately pursuant to initiation of investigation of the applicant. Also the statement of, then I'll come show the date when the summons was issued to her and when this person retracted.
No, but at that time, Arun Pillai was in your custody. When you say that he has retracted his statement, so how is he made responsible for retraction of that statement?
Therefore, I'll show Malad how it was done. Even if he was not in my custody, he was in jail custody, how it was done, I'll show.
He was behind the bars.
Behind the bars, there can be persons meeting persons behind the bars also.
He was
It
in
is
ED
not
custody.
that behind the bars it is solitary confinement where nobody meets. Day in and day out, lawyers, family friends, others meet. And if you are influential, so many others also meet. It is not as if that if you are behind bars, nobody can meet you. Now kindly now have a look at my counter of the ED at page 19. Para 25 at page 19. Kindly note, my lord, statement of this Arun Pillai was recorded page 11th of November 22, page 19, para 25. That the statement, my lord, got it? Page 19 of the counter, para 25. Heading is G, my lord. Heading is petitioner's influence in bold co-accused persons to withdraw their statement given under section 50 of the Penal Code.
Yes.
Para 25. That statement by Arun Pillai was given on 11th of November 22. Kindly note the date. Was sought to be retracted on the fantastic ground of coercion after 118 days, that is 3 months and 28 days, by way of application on 9th of March 23. It is quite bizarre that it took 118 to realize that he was coerced or there was something intervening which led to his retraction. It is apparent that the hearing gets considerable influence so far as the first summons issued to her was on 7th of March 23 for a personal appearance on 9th. Moment summons was issued to her, he retracts. Which clearly prompted Arun Pillai to file an application for retraction on the same date, 9th of March 23. True copy of statement is R1, true copy of retraction is R2. True copy of summons is also there. Because I need not take my lord, but that's. Now, my lords are aware that your lordships have taken a view that if you are produced before the magistrate, 3 months he must have been produced at least 6 times because he is required to be produced every 15 days. He never makes a complaint. If he doesn't make a complaint, in Ganesh, your lordships are held, if he doesn't make a complaint, subsequent is an afterthought, may be prompted by some lawyer's advice or third party advice. That Arun Pillai was arrested on 6th of March. Kindly now have a look at para 26. That Arun Pillai was arrested on 6th of March 23 and produced before London Special Court on 7th of March 23. However, never mentioned or raised any concern before the London Court that he was coerced. The Honorable Supreme Court has held that if you have not sought to retract the first available, it raises serious question over the credibility of such retraction. This is on the retraction, so I may not go into that.
This will be relevant at the stage of a trial.
Yes, but even retracted confession can be admitted. Then your lordships have said it again. H is that it should be within a reasonable time. That is also as well as precedence.
How do you say appellant is or petitioner is responsible for the retraction? Where is the link?
No, you have to
That is
correlate.
circumstance.
No, they are saying that the days he was summoned, immediately thereafter he retracted. So we have to draw an inference that
That is one of the circumstances.
we have to draw an inference that he was responsible for.
Inference. Now kindly have a look at statement of Buchi Babu Pilot dated 28th of March 23. In the summons given to her, it was mentioned that she will be confronted with this Arun Pillai. Now kindly have a look at that summons, my lord. R4.
Yes, yes.
This is the R4. Page 110, Manoj. This will it is in the attached mail, not in the summons, but in the attached mail, I can produce it.
Yes, what do you want to read from this?
Yes, kindly have a look at. Question 1. This is from Buchi Babu. Are you feeling pressurized or?
Oh, where is that?
Question number 1 on the first page. It's the bottom page. Are you feeling pressurized or threat from anyone outside to retract your statement given under section 50 of the PMLA? Answer, I would like to state that after I got released from Tihar on bail, I was called to ED office for summons. Shri Nitish Rana contacted me on 6th of March 23 and said that he had resigned from ED and now he could address my case. After Shri Manish Sisodia's arrest, when my statements came into public, then Shri Nitish Rana contacted me and told me to retract my statements I had given to ED on 23rd of February 23 28th of February 23, 23rd and 20th of February TRJ. Nitish Rana had also met me on 3rd or 4th February 23. Where I was told Arun Pillai to go and meet his friend, lawyer Nitish Rana. Since I was scared and was called by CBI, I met Nitish Rana on the road. In the vehicle I was traveling. He told me that day that I should not worry about CBI anything. A few days down the line I was arrested by CBI. Then my Nitish Rana has been contacting me since my bail tentatively on 12th or 13th of March. He's been telling me to retract my statement, and now Arun Pillai has also retracted, and only my statement is there against K. Kavitha, and thus I should do the same. Now this Arun Pillai is a lawyer, but I don't want to make allegations of a lawyer. He's a lawyer, probably is also there in the Supreme, but he is the lawyer who directly, and is the lawyer for the accused, directly influencing. Both Kavitha and Pillai is the lawyer. So he contacts the witnesses.
Kavitha means the applicant.
Yes. Even in the present case, can't you have a look at the earlier order? Impugned order also. Can't you look at the impugned order? Yes, done. Page 1. Now kindly look at the list of lawyers, his name is there.
Page.
Page 1 of the impugned order. After the senior advocate's name is there, his name is there. Even in the second bail application, after the senior advocate, his name is there. He appears both for Pillai and Kavitha.
Who?
This Nitish Rana.
He was an ED officer.
He was SP, Special Prosecutor for ED. And what's my recollect what happened in the BMW case? The one or two lawyers lost their ground for tampering with witnesses. One or two lawyers lost their ground for tampering with witnesses.
There is a limit. There is a limit to which they will.
Yes.
So Raju, Arun Pillai is also an accused. Let us take the unretracted version of this. Legally, purely legally. Insofar as his attempt to implicate the appellant, what will be the evidentiary value? He is a co-accused.
Co-accused, tried together, section 13.
Right together. So you will have to first marshal the other evidence. This won't be a substantive evidence in itself. You will look at it
It may have
for lending assurance. For lending assurance. You can't start with it, Kashmira Singh.
Yes, but I am not on that. That is a confession. This may not be even a confession.
So it has to be a
Kashmira
confession.
Singh deals with confessions.
So if Arun Pillai implicates himself and attempts to implicate somebody else, then it's a confession of a co-accused.
Confession of co-accused.
Provided there's things incriminatory against the person giving the statement, then only it becomes a confession.
Yes,
Then he is implicating co-accused.
yes.
So then you don't start with this.
I don't start, but it has some evidence.
You will have to see for lending assurance.
Lending
You have
assurance.
to marshal the other evidence and then look at it for lending assurance.
We have independent evidence, but this is also evidence. Maybe it
I'm
is
ignoring
of cognitive nature.
We are ignoring the retraction and going by the unretracted statement. Just to put the legal perspective in the whole argument. So, independent of this, something has to be shown.
Yes, I'll show independently. They have not gone into, but I'll show independently that we have a strong case independently also.
Yes.
May I show her role now, Manoj, so that independently what is the evidence as far as role is concerned? I'll read from the counter first so that we. Page 6. Give the counter. Page 62 of my counter. Then I'll take my lordship's statements also if required. Para 78. My lordship got it?
Yes.
This is Dawai has got it. Yes. Role of petitioner to ensure. He is one of the kingpins and a key conspirator and beneficiary of Delhi excess policy scam. She, along with other members of the South Group, Sarath Reddy, Raghav Magunta, and Sri Magunta Srinivasalu Reddy, conspired with the top Aam Aadmi Party, the top leaders of Aam Aadmi Party, gave them kickback to the tune of 100 crores, and in exchange got undue favors in the Delhi excise policy formulation and implementation. She, Kavitha, orchestrated a deal with CM Delhi government, Sri Arvind Kejriwal, and Deputy CM and Minister of Excise Manish Sisodia, wherein she, along with other members of the South Group, paid them kickbacks through a string of intermediaries and middlemen. In exchange of kickbacks paid to the leaders of AAP, she had access to the policy formulation and offered provisions to ensure favorable position to her. She further got stakes in partnerships of Indo Spirits through her dummy, Arun Pillai. Arun Pillai was a dummy front for her in Indo Spirits. Without substantial investment in this firm and distribution business of Mrs. Pernod Ricard India Limited, it is one of the biggest manufacturers in the country and thus made Indo Spirits the most profitable L1 in Delhi excise policy 21-22 period, thus recouped the proceeds of crime in guise of profits. Further, the policy of profit margin, the wholesaler was increased to 12% so that this margin, a portion of it could be taken back as kickback. This was done to recoup the kickback. This was done to create a continuous stream of illegal funds from Aam Aadmi Party in the form of kickbacks from the wholesalers and for the South Group to recover the kickbacks paid and further generate profits from this entire conspiracy. Her role in kickbacks. Kavitha, along with others, have paid 100 crores bribe to the top leaders of Aam Aadmi Party. The same is evident from the following. One.
Yes.
Statement of Magunta Srinivasan Reddy dated 14/7/23 recorded under section 50 of the PMLS statement dated 17/7/23 recorded under section 160 of CRPC. In the month of March 21 during Parliament session, I had seen the newspaper in Delhi stating that privatization of liquor trade for government to private, since we are in liquor business for the last 71 years in southern India. Hence, we thought of coming to Delhi since it is in the hands of government. We thought we can do liquor business in Delhi. And to know from the government, I've asked for time to meet Sri Arvind Kejriwal. Then his office had given time for me for the meeting of Secretary's office in 16/3/21 at 4:30. If my lord has a look at the CBI papers, all this is evident that CBI has recorded a statement of one Rajesh or Rajiv, who is his PA, and the time was asked for. Of course, the purpose was not mentioned, but time was asked for. When I met him, he was cordial in that we welcome everyone to Delhi to do business. Regarding liquor business earlier, Kavitha, daughter of Chief Minister so-and-so, had already approached me to do liquor business in Delhi and offered to pay 100 crores to the party, that is the Aam Aadmi Party. And she'll call you in the liquor business connection, or you call her, discuss about future. Already their team is working in Delhi. So this statement of Magunta Srinivasan Reddy reveals this. This is one evidence. It's a section 50 statement apart from 164 and 161 which is there in the CBI paper. That following this, Kavitha called Sri Magunta Srinivasan. Therefore, Kavitha called. Now that phone is formatted. On 19th of March 21 and asked Magunta Srinivasan Reddy to meet her. Next day, Sri Magunta Srinivasan Reddy went to meet her at her residence in Hyderabad. In that meeting, Kavitha told him that Sri Arvind Kejriwal had spoken to her and asked her to give 100 crores. And accordingly, he asked Magunta Srinivasan Reddy to arrange 50 crores for the same. The Kavitha told him that her CA, Uchi Babu, will visit him and his son Raghav Magunta to coordinate for this. That Sri Uchi Babu visited them the next day and Raghav Magunta told him that he could arrange 30 crores and finally 25 crores was paid in cash to Abhishek Goenpalli, Sri Bachu, and Sri Uchi Babu on instructions of K. Kavitha. This is her statement of...
This is a statement of?
This is statement of Magunta. Raghav, the statement of Magunta Srinivasan Reddy. I can take my lord to the statement, or where is that text? 62 of the convenience compilation. ED convenience. Yeah. That's when see, kindly have a look at 62 of the convenience compilation. Have you given any kickbacks to Aam Aadmi Party in Delhi liquor scam? I also got it, page 62, second last paragraph of my ED convenience compilation.
Yes.
Question number 1 at page 62, somewhere second last paragraph. Have you given any kickbacks to Aam Aadmi Party in Delhi liquor scam? Answer. This is Raghav's statement.
Raghav Magunta, that's what I was saying.
Yes. Page 30. Kavitha.
Used to be able to find out when
Muchata statement. Give me Muchata statement. There is. Page 53, I'm sorry, ma'am, page 53. I put the card before the horse. Because I will come to the Sun statement also, because it supports and corroborates. Question 1 at page 53. Please tell me, my lordship got it? Please tell me whether you have given any kickback to the Aam Aadmi Party in Delhi liquor scam. In February, March 21, I had come to know that
Question number?
bringing a new excess policy.
Still one.
Question number 1 at page 53 at the bottom.
53.
53.
Yes.
Of the convenient edict. This is a statement of M. Magunta Srinivasan Reddy, father of Raghav. In February, please tell whether you have given any kickbacks to Aam Aadmi Party in the Delhi liquor scam. In February, March 21, I had come to know the Delhi government was bringing a new excess policy wherein the retail sector was being privatized. Since I and my family have had long experience in liquor business, I thought it was a good idea to enter Delhi liquor business. To understand more about the same, I visited Sri Arvind Kejriwal, CM Delhi, in his office. My office had scheduled this meeting with Sri Kejriwal's office staff. This meeting took place on 16th of March 21 at 4:30 p.m. During this meeting, Sri Arvind Kejriwal was very excited about upcoming policy and business opportunity it was going to bring for everyone in Delhi. Then I also showed my interest in participating in the Delhi liquor business. To that, Sri Arvind Kejriwal was very welcoming and said he would support my ventures in the industry since I have such a big name down south. Then he said that K. Kavitha, daughter of so-and-so, is also interested in entering the Delhi liquor business. He said that he is already in discussions with her and their mutual interest in fulfillment. Then Sri Arvind Kejriwal said that Sri K. Kavitha had agreed to give him funding for the elections, etc., and exchange for help in Delhi excess policy and generally in liquor business in Delhi, and that I should also give him funds and that he would help me in upcoming policy and business. He said that I should talk to K. Kavitha and she will get in touch with me and that we can both work together. He said Kavitha will coordinate the nitty-gritties of the same. He said the team is ready working the excess policy of his team. He said that his guy, Vijay Nair, was working with K. Kavitha's team. That this is the starting point, Lord. her name is revealed here and revealed by Arvind Kejriwal. Now come to the meeting with Kavitha as far as what is that statement? Where is that statement regarding meeting to meet her and then discussion? What is here? Now kindly, my lord, kindly then further, page 54, the next paragraph which I missed. I then informed my son Raghav about the same and asked him to coordinate from there on, since he was the one who actually handling the business also, and I was mostly busy with MP responsibilities. After 1 to 2 days, K. Kavitha called me on FaceTime, WhatsApp, and deletion or formatting makes an important this thing, and asked about my meeting with Mr. Kejriwal. She said that we should work together in this. Then she asked if we could meet to discuss this plan. So on 20th of March 21, I went to meet her at her residence in Hyderabad. In the meeting, she informed that Arvind Kejriwal had asked her to give 100 crores and that I should pay 50 crores approximately. For the same in exchange, Arvind Kejriwal will make sure that there is favorable policy clauses for us and business will be given all help, support and priority. To her, I told her that my son Raghav will coordinate in this regard. K. Kavitha said that her person, Sri Bucci Babu, will visit me and Raghav to discuss the details of the business and the money to be paid. A day later, on 21st March, Sri Bucci Babu visited me and Raghav at my residence in Hyderabad at plot number 303 MP MLA Colony, road number 73 in Hyderabad. In this meeting, we figured Bucci Babu is from my constituency and we had even met somewhere in the past. Raghav then discussed the matter with Bucci Babu and they continued the meeting. After the meeting, Raghav told me that he had agreed to pay 30 crores instead of 50 crores asked by Sri Kavitha. The details of payment can be given by my son. However, he had informed me that he had given 25 crores to K. Kavitha per person, Bucci Babu and Abhishek Banpali. In between, whenever Raghav had any issues for NOC for airport zone from GMR, I also intervened and spoke to GMR. That's a difference. Now come to Raghav's statement, which I was referring to. Now, my lords, may kindly have a look before I go there. Here is a 64th statement of Magunta Srinivasan Reddy, which is recorded by the magistrate under 56, under section 164. It is at page 56. Now, kindly look at what he states. Page 6. It starts at page 56, but the relevant statement starts at page 58.
Of the same compilation.
Yeah, same compilation. Then the first page is page 58, which is meeting with Kejriwal Manoj. The last paragraph. When I met him, he was cordial and said that we welcome you, everyone in Delhi, to do the business. Regarding this liquor business, earlier Ms. K. Kavitha, daughter of Chief Minister of Telangana.
Not legible at all.
Pardon me? So,
It's not legible at all.
yes, my copy is also same. Therefore, I read the last paragraph. It's the same as section 50. Therefore, it says the same thing. That I met Kejriwal. Kejriwal said he was in talks with Kavitha and he should meet her. Then my 59 onwards is legible, Bharat. Has already approached me. Kavitha has already approached me to do liquor business in Delhi and offered to pay 100 crores rupees to the party, that is Aam Aadmi Party, and she will call you in this liquor business connection. Or you can call her, discuss about the future since already their team is working in Delhi. Later I got a call on 19th March 21 from K. Kavitha asking me to meet her. We went the next day, that is 20th of March. On 20th of March, I met her. She has told me that Mr. Kejriwal has spoken to her since I have got much experience in liquor business. She asked me whether I can arrange for 50 crores. Since I was busily involved in my MP daily activities, I have informed my son Raghav Magunta.
It is the same
thing, but it is before a magistrate. So it is not before an ED officer or a CBI officer. It is before a magistrate.
Raghav is shown as an accused in the 6th supplementary. Magunta,
He's turned an approval.
he has turned an approver.
Yes.
Accused turned approver.
CBI is not an accused. In ED, the accused turned approval.
So it's required corroboration.
All these witnesses have turned approver. Their statements which he is reading are when they became approvers. Five statements recorded prior to becoming approver do not name me or Sisodia or Kejriwal. And all the, 1 minute, and all the statements in detail are reflected in Kejriwal's order. At least you should have said that. You should have filed all the statements without he read to the Lordship Pillai's statement. Pillai made 5 statements before the statement concerned. 5 statements, in which he names nobody. In the 5th statement, when he is in custody, he names these people. At least you should be fair to say this. I'll show you, Lordship, not one
I'm
by
showing the evidence, I'll show what it is, what is the law.
all the statements are reflected in the order of Kejriwal. Please. All the statements are reflected. You cite these statements in every case, whether Kejriwal, whether Sisodia. So there are not several kingpins. Kejriwal is the kingpin, Sisodia is the kingpin, I am a kingpin. And the same statements of this Milord, the son of Magunta, Raghav, gets pardon, gets bail within a week, and then gets Milord approval, bail and pardon.
Pardon is given by the.
So 1 minute,
Pardon
this is how it is. Sarath Reddy,
Different may argue.
approval.
Let him argue.
But Milord, this is only a bail we are arguing.
Almost arguing as a
This is
trial.
not a case, Milord, of trial.
I'm pointing out the role, I'm not, there are so many, there's thousands of.
There is no other evidence except these statements of these, tainted statements of approvers. Five statements before they are turned approver, you don't file them.
We are called upon him.
Sorry,
Must follow some
I'm sorry, Milord, my friend is
discipline.
going on as if they are arguing without a conviction or a trial.
I'm not arguing a trial, I'm
Then-
sorry, this can never be argued in a trial. Trial, you look at the depositions, you look at so many other things.
You are reading every day.
Rogi, we had asked him, when he started with the confession of the co-accused, we had asked him for evidence independent, which can be marshaled. That
There
is
is
how.
no, except Milord, these
No,
statements.
But then now we realize that he is an approver. In which case,
He should have said that.
Sir,
Why
Raghu-
doesn't he tell you, Lordship? Each
Chibabu
of them is an approver.
approver.
approver also will require corroboration.
Then,
Yes, but there are others who are, therefore I'm showing the evidence.
Don't argue like you are arguing.
Merely because he says that,
I-
it's not so, my lord.
Yes.
Therefore, my lords may kindly have a look, I'm not arguing, there are so many hundreds of statements, I'm only relying on the relevant statements that.
And these are all statements which are also relied in Kejriwal's case.
yes.
Kejriwal has been granted bail.
Not to the extent that.
No,
he knows-
Kejriwal has been granted bail in ED case.
No.
Yes.
Yes, of course.
He has been granted bail in ED case, and insofar as
Interim bail has been granted.
insofar as CBI is concerned, I think that is pending before the
Correct.
other bail.
It's coming up next
Pending
week.
before the court.
That is next week.
The EBI case on the ground of arrest, though the question was kept
Hey,
open.
please, don't argue. If you are going to argue bail matters like this, then every day we can take only 1 or 2 bail matters. We don't permit lengthy arguments because the parties are.
No, I'm not saying that. I'm only pointing out the
So
role.
you should argue it like an ordinary bail application. Not because the parties are celebrity, we should
No,
permit an hours and hours of this
I'm
court.
sorry, Malad, if I've conveyed that impression. I have not done that. I'm only pointing out to the evidence. I have not made any irrelevant or showed any irrelevant papers. I've shown everything that is relevant.
This
Now,
would, no,
as far as Magunta is concerned, it's not like-
Yam Narsula Reddy, he has also been, he has also done approve.
No, Magunta Reddy, no.
Mugunta made a witness that.
Milord, Magunta is a witness.
He's a witness, he's not an accused.
He's not even accused.
Father
He's not an accused.
He's not an accused.
he is incriminating himself, yet he is a witness. His son is the approver, Rahul.
Indicates
Approver, bail and pardon within 7 days.
Sorry, when we expect
Sorry.
that a lawyer to whom we ask query
I'm sorry.
answers it.
I'm sorry.
He's not an accused.
Son deals with it. My lord,
He is not made an accused, the son is made an accused and approver.
Yes.
Sorry to
But,
see this state of affairs.
but as far as whether to make a particular.
If he has a role, his role is almost equal that with that of Kavitha.
In fact,
So you will pick and choose anyone.
first meeting was with him, with
With Arvind Kejriwal.
the first day.
And Arvind Kejriwal tells that Kavitha is also interested, so you coordinate with Kavitha. And he is not made an accused.
The nitty-gritties of that, it was a brand, I came to know. After it has.
No, everything has been finalized at his residence.
Thereafter washes his hands, it's his son who is dealing with it. He washes his hands thereafter.
No, he doesn't say
He is not involved, he is not involved in giving out bribes, not involved in the
The prosecution has to be fair. You can't pick and choose anyone.
The prosecution is fair, but it's not.
What is this fairness? A person who himself incriminates has been bid and witness.
Incriminate, yes, but he
Tomorrow you will pick up anyone as you choose and leave anyone as you choose as an accused.
that unfortunately the
Oh,
given state.
very fair and reasonable discretion.
319 power.
CRPC.
Very fair and reasonable discretion. You want to observe all that in our order.
If
We'll observe that if you want.
you had taken the 306 route, a different matter. PRPC. Now, he now is having a status higher than a approver because he is a witness whose 50 will be per se admissible, and he will have a role of witness, whereas the substance of it shows that he will be directly involved. That is why provisions like 306, isn't it? Tender of pardon to accomplice.
But my lord, even as a witness, he'll be subject to cross-examination.
No, but he will not have the status of an accomplice, you see, though in substance, an accomplice.
Whether he's an accomplice or not will be a
And
decided to the court when it's placed reliance on his.
And Buchi Babu is also an accused.
He may accuse not in this case,
Not in this.
not in ED.
There is a beautiful phrase in which judgment, I don't know, was it R versus Baskerville, accomplice of the darkest hue. Darkest hue.
And Gautam Muthu,
Accused in CBI.
not in ED.
No.
It is only if you have a role in money laundering, you have made an accused.
So Buchi Babu has a role.
Not in money laundering.
Yes, he is a conduit, according to you. He receives the money.
Not taken any money, not involved in the.
No, you said the statement which you read
Yes.
some time back clearly says that he received the money
Yes.
on behalf of Kavitha.
Yes,
The first 25 crores.
Yes.
yes.
100 crores to be paid. So 25 crores are, somewhere we read it.
Yeah.
Anything more? The more you argue, the more observations you will invite. That we are telling you now.
On women, what do you stand? 2 minutes. Constitution Article 15(3) uses the word woman.
Yes.
This 45 uses woman. 437 CRPC uses woman. The
That is one uses.
uses woman.
Yes.
Now, are we to read categories of women into it? How do we proceed in law? 15(3) article I just checked up. Constitution says special provision can be made for.
Therefore, equality will not be breached if you have.
Woman is a woman. It's a status has been given in the statute framed by the parliament.
My apprehension is this. It may not open doors for all women.
The appeal shall leave granted.
May I?
If you want to, but then we are putting you on guard. If you take us in detail, we will observe everything. We will have to observe about the fairness and impartiality of the investigating agency.
I have only apprehension for this.
If you want those observations, then you argue more.
I don't want the observations. Though observation of bail.
We know. So therefore, we will avoid going into the detail.
Despite that law, but it has a weight, I also know.
No.
Despite the law that.
Consistently, the court has been saying that the elaborate evaluation of the evidence at the stage of bail should be avoided. Then we will ask.
Say this, my lord. On the condition that.
Let's see the woman.
Only on woman, not delay, etc.
No, on 3 grounds. Investigation is complete. The charge sheet is filed. In that ED case, the complaint is also filed. 2, 493 witnesses. Likelihood of the trial being not concluded within a short period. And 3 women.
Not to, or is it possible for not to give reasons on my concession? Because then all witness, or in the cases, supposing a person is arrested today, tomorrow he'll say there are 493 witnesses. That will go against me, but those observations will go against. Every woman arrested will get bail.
No,
My lords may say on the peculiar facts of the case.
No. We must give some reasons.
Peculiar fact not to be treated as
Or we'll say that Mr. Raju, after arguing for 1.5 hours.
No, I have not completed, I have not, my
But
lords.
you argue, but then you will invite each and every objection, then you would make a decision. Then if you make any observation with regard to an unfair conduct of your investigating agency.
I come back at 2 o'clock.
Yes.
I'll come back.
Any observation with regard to unfair investigation we don't know what effect it will have.
Then I'll have,
Or otherwise, we are restricting it only on these 3 grounds, that the investigation is complete. So far as Tampering is concerned, we will put her to conditions. And women we have to observe, because this fantastic discussion that an educated, sophisticated woman is not entitled to the statutory benefit is something it requires to be commented upon.
On the ground that she's a woman, but in the facts of the case, looking to the period of.
We'll say that, but no, but this we have to tell. Otherwise, this will be a law, at least insofar as Delhi High Court is concerned. No educated woman will be entitled to get benefit of.
Say that those observations may not be treated as.
No. We're saying that we are going to say that those observations are perverse. Tomorrow, if these observations remain, every woman, because the judgment of Delhi High Court would at least bind all the judges within the jurisdiction of Delhi. May not any other High Court.
Once my lords grant, then observe that because she's a woman, then all those observations pale into insignificance.
No, we have to comment. We have to have some comment upon those. What is this? Merely because she is an educated, she is a member of parliament. On the contrary, we say that we should not discriminate when we consider denial of bail, whether he is an MP or is an MLA, he should not get a special treatment. And now for denying, you are giving him a special treatment.
But my apprehension is.
We are not. We will observe that. We will observe that it doesn't say, but then finding out this artificial discussion is finding out something which is not in the statute.
Then my lords may protect us by saying that this whatever observation my lords do not apply in all cases.
Yes, that
depend on facts of each case.
That we do in each and every case. Even in Manoj Siside, we observed that they are only for the purpose of grant of bail. And will have no bearing at the stage of trial.
In the facts of this case, because of the lengthiness of the trial, and also because she's a woman, my lords may by two lines pass the order without going into
the. It has to be, if you are, this matter has been argued for 1.5 hours, at least give us 5-6 pages.
Yeah. Why is this being argued in this fashion?
At least leave granted.
Only on this ground.
Yeah. The appeal challenges. Mr. Rodi. Appeal challenges. The judgments and order passed by the learned single judge of Delhi High Court in bail application number.
I come back at 2 o'clock. I most probably I'll consider 2 o'clock.
Bail application number so and so. If you come at 2 o'clock, then we might change our mind.
My favor, then I.
Not in your favor. Not in your favor.
But
You are
change of mind,
arguing.
as I understand.
You are
change of
arguing.
mind can
No, no.
always be in my
No,
favor.
you are arguing.
What my lord
No, no. You are
said.
arguing a matter before a bench which has granted bail to an accused against whom there are more serious allegations. He was supposed to be kingpin.
But he was 18 months behind.
No, Sir Raju, you would have still won because law would have won on as it stands today. So in that sense, you are saying.
Yes.
The-
Therefore, my lords may kindly have a look, Lord. Protect us to the extent that
We are going to protect this. Don't worry about that. But we want these observations to go of vulnerable woman.
my lords will say we do not agree with this observation.
Oh, no.
Not
The appeal challenges so and so, and in bail number so and so, by which the learned single judge has refused to grant bail to the petitioner. Paragraph. So, the matter has been argued at length by Sri Mukul Rohadgi, the learned senior counsel, along with Sri Naidu and Sri Chaudhary, the learned senior counsel, and Sri Raju, the learned ASG, at length, paragraph, at length, comma, Sri Raju, the learned senior counsel, has suggested that this court should avoid elaborate discussion of the evidence in as much as any observations may prejudice the rights of the party, rights of either of the parties at the trial. Paragraph. We appreciate the fairness of the learned ASG in suggesting the court not to record the detailed elaboration of the evidence. So, as a matter of fact, it is a consistent
and
law.
what we say merits instead of evidence. Evidence will be after the deposition. Instead of
Detailed elaboration of the merits of the case. First one. It has been a consistent law of this court that this court should avoid elaborate discussion at the stage of grant of bail. Paragraph. Sri Raju, the learned ASG, उसके पहले इनका लेना पड़ेगा. You are sitting from morning, so we'll have to at least give some. Sri Rohadgi, the learned senior counsel, appearing on behalf of the petitioner, submitted that there is no material on record so as to implicate the petitioner with the offences charged with. In any case, he submitted that insofar as the ED case is concerned, the prosecution complaint has been filed, and insofar as the CBI case is concerned, the charge sheet is already filed. First off, he submitted that since the investigation is complete, no further custody of the applicant would be required. Paragraph. Sri Raju further relying on, Sri Rohadgi further relying on the judgment and order of this court in Monastery Kalele, so and so. Submit that. But Kejriwal is by which court? This court, but that was an interim bail.
that was for
Interim bail only for election purposes.
Kejriwal arrest has been upheld.
Yes, sir, it is interim, different to a larger.
Submit that. Like in the said case, in the present case also, there are about 493 witnesses to be examined, and the documents to be considered are in the range of 50,000 pages. He further submitted that no proceeds of crime have been recovered from the petitioner, from the appellant. Sri Rohadgi further submitted that the petitioner is a woman and therefore entitled to the special provision under clause 5,
Provision to 40.
under proviso to section 45. 45 into bracket 1 of the PMLA Act Correct. Shri Raju vehemently opposed the application. He submitted that the statements of various witnesses as well as the co-accused would clearly show that the present appellant was a kingpin in arranging the deal between the accused Arvind Kejriwal and the South Group, South Lobby. So he submitted that the witnesses, the statement of the witnesses clearly show that the proceeds of the crime have passed through, or at least at her instance. First, the Sri Raju further submitted that not only the statements recorded under Section 50 of the PMLA Act, but also the statements recorded under Section 164 of the CRPC before the learned magistrate would clearly implicate the present applicant in the crime. Paragraph. Sri Raju further submitted that the learned trial judge has rightly refused to grant the benefit of proviso to Section 45 into bracket 1 of the PMLA Act on the ground that she is a woman, in as much as she has indulged herself into tampering with the evidence and influencing the witnesses. First, he submitted that the appellant has formatted the phones was to destroy the evidence which was against her. First, it is further submitted that the sequence as to how Arun Pillai is accused or witness. She further submitted that the sequence as to in what manner the accused Arun Pillai has retracted his statement would clearly show that it is the present appellant who has a role to play in that. She submitted that though the statement of Section 50 of Arun Pillai was recorded on 10th of November 2022, after a period of more than 4 months, he has retracted the statement on 9th of March 2023. That is the day on which the first summons was issued to the present appellant.
Issued on 7th, received on
on 9th of March. The first summon was issued to the present appellant on 7th of March. That is 2 days prior to Arun Pillai retracting his statement.
summons is to Kavitha.
Therefore, we said appellant.
Yes.
Appellant is Kavitha. He therefore submitted that the court will have to draw an inference that the appellant is indulging into influencing the witnesses. Paragraph. As suggested by the learned ASG, we do not propose to go into the merits of the matter. First of all. However, it is to be noted that the reliance is mainly on the statements of the co-accused, some of whom have been granted pardon and have been made approval. First of all. You want to
Say this, why? Saying that give it on the ground of
So we are only saying that
why this, my lord? This will hurt us going in the trap. Why I'm saying
okay. We are not going to the merits of the matter. Also, we find that, however, the investigation is complete. So no doubt that, as was argued before us in the case of Manoj Sisodia,
Manish.
Manish Sisodia,
I don't think Manu.
Manish Sisodia, according to the prosecution, the investigation here is continuous and still going on. No, you made a statement in Manish Sisodia, it is still ongoing.
Thereafter, the charges were filed.
No, but
I didn't know.
no.
Was made.
Manish Sisodia made a statement that it is ongoing and therefore you had opposed the bail on that ground also.
No, that was the earlier order, Manoj.
No. Manish Sisodia came before me only once.
No, before another bench during vacation, that
We
statement.
know about that.
Therefore, not before my lords, I never made a statement. I said the charges have been filed. Complete.
Correct. As such, the custody of the applicant is not necessary, appellant is not necessary for the purposes of investigation. First, paragraph. The appellant is behind the bars for last 5 months. Also, as observed by us in the case of Manoj Sisodia, take into consideration that there are around 493 witnesses to be examined and 50,000 documents to be considered. The likelihood of the trial being concluded in a near future is impossible. First up, paragraph. Relying on the various pronouncements of this court, we have observed in Manish Sisodia that the procedure itself, procedure resulting in under trial custody should not turn into a punishment. First of paragraph. We are further of the view that in view of the proviso of subsection 45(1) would entitle a woman to be a woman for a special treatment while considering.
May I only suggest that
Application.
there's 3-judge bench observation which says it's discretionary.
We are observing that.
Steer clear of that and say on peculiar
No,
facts.
sorry.
Kindly, therefore, I am only saying it may not be contrary.
Now, if you argue anything more, we will go to Narasimha Reddy and as to why is not
That is on
made.
bail, Manoj. I am only saying that my lords may not. Which is in conflict with 3 judges bench. That's all that I am saying.
Before permitting us to complete,
Well, I'll leave it.
before permitting us to complete, how can we come to a conclusion that we will be passing? No, before permitting us to complete our order, how can we anticipate that we are going to?
I'm only
No,
saying.
how are you anticipating that we will be passing something contrary to the 3 judges order?
Where they've interpreted 45. I'll leave
Yes.
it to man. That's all that I will say.
Correct. The proviso reads thus. First of all, the proviso of the proviso does release that. The proviso permits certain category of accused, including women, to be released on bail without the requirement, twin requirement, correct, under section 45 to be satisfied. Full stop. No doubt that, as argued by the learned ASG, in a given case, the accused, even if a woman, may not be entitled to the benefit of the said proviso. It will all depend upon the facts and circumstances of each case. Paragraph. However, when a statute specifically provides a special treatment for a category of accused, when denying that benefit, the court will have to come to a specific reasoning as to why such a benefit is to be denied. Paragraph. The order of the learned single judge, which denies the special treatment to the present appellant, makes an interesting reading. The learned judge observes thus paragraph 65 to 68 poster. Paragraph. Day in and day out, it is argued before us on behalf of the prosecution that merely because an accused has a special status like he being an MP or MLA or minister or chief minister, he should not be given a special status and he should be treated equally with the other accused. However, paragraph, the learned single judge in the present case, while denying the benefit of the proviso to section 45(1), comes to an interesting conclusion, comes to an heartening conclusion that the appellant is a highly qualified and well accomplished person having made significant contributions to politics and social work. Also, the court observes that while deciding the bail application, the court may appreciate her accomplishments. It cannot lose the sight of serious allegations leveled by the prosecution and the evidence collected during the course of the investigation and presented before this court. Paragraph. The learned single judge proceeds to observe that the present appellant cannot be equated to vulnerable woman. Also, the learned single judge observes that the proviso to section 45 is applicable only to vulnerable women.
Whereas women are vulnerable. That is different.
Further find that the learned single judge totally misapplies the ratio laid down by this court in Soumya Chaurasia versus Directorate of Enforcement reported in so and so. Per contrary, the learned judges of this court observe that the courts need to be more sensitive and sympathetic towards the category of persons included in the first proviso to section 45 and similar provisions in the other acts. First of all, the court observes that the persons of tender age and women who are likely to be more vulnerable may sometimes be misused by unscrupulous elements and made scapegoats for committing such crimes. So no doubt that the court observes that nowadays the educated and well-placed women in the society engage themselves in commercial ventures and enterprises and advertently or inadvertently engage themselves in the illegal activities. First of all, the court therefore puts a caution that the courts, while deciding such matters, should exercise the discretion judiciously using their prudence. First of all, the court does not say that merely because a woman is highly educated or a sophisticated or a member of parliament or a member of legislative assembly, he should be denied the benefit of the proviso to section 45(1). So we therefore find that the learned single judge has totally misdirected herself while denying the benefit of proviso to section 45(1) of the PMLA Act. In the result, we allow the appeal. Paragraph. The impugn order dated so and so in so and so in so and so is quashed and set aside. The appellant is directed.
Satisfaction of promise. This limit in condition doesn't apply.
to be forthwith released on bail in connection with so and so दोनों केस का नाम ले लेना on punishing bail bond in the sum of rupees 10 lakh each in both the cases. 3. The appellant shall not make any attempt to tamper with the evidence or influence the witnesses. The appellant shall deposit a passport with the learned trial judge. He shall report when? Once in a 15 days or once in a month?
There's one thing I must say. His observation regarding witness exercise will be the slight difference in CBI case as well as but I'm not arguing on merit. On factual aspect, there might be slight difference, but one thing in their favor is CBI case 45 doesn't apply, and maximum punishment is 7 years. Ordinarily, laws have taken the because 7 years bail is to be granted plus is a woman. So those facts are slightly different in their favor from CBI matters.
You want to add all that?
I'm only saying factually it may be covered or not covered. The number of witnesses, etc., will be slightly different. I'll pass it on as a piece of paper if my lords want it.
Corrected. We can say that he did.
Not to be.
But reporting is not required now. No matter before the court, I will appear.
Why is he arguing for others? This matter is always got.
I'm talking about myself.
Saying not to
I
be in
will,
the
because she's an MLA, she
So,
will.
once a month,
We'll pay for the court regularly.
Once a month is all right. I'll leave it to her.
What will she do? She just go and mark attendance. She will appear.
we'll ask her to report to
Whenever called for. My lords may say whenever called for. We'll not mark.
whenever call for, then you will unnecessarily call. Or we will add.
No, what he's saying is,
He will most probably not call because now investigation over, charge sheet is filed.
Now before the court. I will appear in the
It says
court.
charge sheet is already filed. The appellant shall.
Yes,
Up to
when
the-
the trial starts, the judge will summon me. I will
He
go.
may appear before the trial court and not prolong the
But
trial.
the appellant shall
Trial hasn't started. You want me to not.
regularly attend the trial court and cooperate with the expeditious disposal of the trial. उसमें ले लेना, उसके अपील लगा के बोले. Though we are not observed on anything, on the merits of the matter, we clarify that nothing observed herein would prejudice the trial. Comment to operative part there committee. बाकी बाद में करके आपके पास देना एक कॉपी. Operative part will be out today.
Great.
We'll get it by 2 o'clock.
Great.
There, there's nothing there.